Hello, good morning, and welcome to Baiju's Exam Prep. First up, we will discuss one topic which we have not covered previously. Then we will look at previous year's question papers. Then we will discuss what are the topics that you need to cover and skip from M. Lakshmikant. And then you have shared a list of questions with us. I'll take a look at these questions one by one and answer. Clear? Pardoning powers available with the president under Article 72, available with the governor under Article 161 of the Constitution. First, I'll tell you what do we mean by pardon. Then I will tell you why pardoning power is available with the president and the governor, and what are the rules for that. Will there be a judicial review? What are the Supreme Court judgments on this matter? And what happened recently in the Tamil Nadu case? All that in the next half an hour. Listen to me patiently. There is something called pardon, and then commutation, then respite, remission, reprieve. You have committed a crime. The district court says you are guilty. You hang by your neck till death. You appeal before the High Court said you are guilty, death sentence. Appeal before the Supreme Court said you are guilty, death sentence. Filed a review petition, dismissed. Filed a curative petition, dismissed. Is there any other alternative available with you? Yes. What is it that you can do? You can file a mercy petition before the president or the governor of a state. President of India, the governor of a state where you have committed this crime. And what are the options available with the governor? What are the options available with the president? The president can pardon you. What do we mean by pardon? Not only will you be set free, you will be free from all disqualifications. Free from all disqualifications. What does that mean? Shri Rahul Gandhi was convicted by the Gujarat High Court for criminal defamation. For that, he was sentenced to jail for 2 years. He will have to stay 2 years in jail, provided Supreme Court also upholds this verdict of the Gujarat High Court and gives the same punishment of 2 years. Which means Rahul Gandhi will have to stay in jail for 2 years. As well as, once he is released from jail, for the next 6 years, he cannot contest elections. But if he approaches the President of India and President pardons Rahul Gandhi, not only will Rahul Gandhi walk away from jail, that means he won't be serving 2 years in jail, he will also be free from all the disqualifications that exist because of that conviction. Because of that conviction, you could not contest election 6 years after the release. The president will say you are pardoned. Not only will you not remain in jail, stay in jail, you are free from all the disqualifications. It is as if you are born out of the womb of the mother today. That is pardon. Why this power is given to the president, we will discuss slightly later. But this is what pardon is. If not pardon, president can commute. What do we mean by commutation? Replacing a punishment with a lesser punishment. Or should we say next lesser punishment? You committed a crime, High Court, District Court, Supreme Court says death sentence. Review petition dismissed. Curative petition dismissed. You file a mercy petition before the president. If the president commutes your sentence, which means your punishment will be replaced by 1 degree lesser punishment. If you were given death, it will be replaced by life imprisonment. If you were given life imprisonment, it will be replaced by 14 years in jail. If you were given 14 years in jail, you may be given 10 years in jail. That means you are being commuted of your sentence. Your sentence, which has been awarded to you, is replaced by 1 degree lesser. And primarily, it is used to when a death sentence is given to an individual, that death sentence is reduced to life imprisonment. That is what we call commutation. You're not pardoned, your sentence has been commuted, which means you will not be set free, but your sentence has been reduced, which means there are still disqualifications. Clear? Or respite. For example, medical condition of a convict. Convict is a pregnant woman, or convict is suffering from some disability. That doesn't mean you will not be punished. That doesn't mean people with disability or pregnant women, they can commit crimes and get away with that. You will still be punished. But for your medical condition, you will be given respite. Scorching heat in Delhi. People in Delhi got respite from the scorching heat because there were showers, unexpected rain. So you are getting respite from the condition that you are in right now. That's what we call respite. So the president, what he can do, can reduce the sentence, can change the character of the sentence as well. What does that mean? This pregnant woman committed a crime for which she was given 5 years in jail, but 5 years of rigorous imprisonment. If she approaches the president can grant her respite because of her medical condition, which means not only will the sentence be reduced, let's say from 5 years to 3 years, but even the character of the sentence will change. Character was rigorous imprisonment. Now this rigorous imprisonment will become simple imprisonment. Simple. Respite because of your medical condition. If not respite, the president may grant you remission. And what is remission? Reduced sentence without altering the character. What if, for example, an individual was given 5 years of imprisonment, but rigorous imprisonment? His sentence can be remitted. Remission can take place. Sentence will be reduced from 5 years to 3 years, for example, but character will remain the same. If it was rigorous imprisonment previously, it will remain rigorous imprisonment. Or it can be reprieve. Reprieve is basically temporary stay on death sentence. For example, I have been convicted by the court. Now the Supreme Court says you are guilty, death sentence. Review petition dismissed, curative petition dismissed. Now I have to file a mercy petition before the president. And this mercy petition, when I file, first I have to accept my guilt. I'm sorry for what I've done. But I can be a changed man. I can be an asset to the society. These are the circumstances under which I committed this crime. And these are the reasons why you should not sentence me to death, why you should commute my death sentence or pardon me or grant me remission or respite. So if the president grants you reprieve, that means there will be temporary stay on your death sentence till you file a mercy petition. That is what we call a reprieve. For example, World Cup is ongoing. Rohit Sharma nicks a ball, and in the slip, the catch drops. Rohit Sharma granted reprieve. That means this is temporary. Rohit Sharma will get out, unfortunately, because that's how it is. It's very rare that he will stay not out. Even his 264, he got out on the second last ball, I think. Reprieve, temporary stay. Which means under Article 161 of the Constitution, under Article 72 of the Constitution, governor and the president, they have the power called pardoning powers or judicial powers. Pardon, commutation, remission, respite, reprieve. These are the 5 set of pardoning powers that are available with the president and the governor. But all these powers are to be exercised only on the advice of Union Cabinet. Only on the advice of the Union Cabinet, because president or the governor does not have discretionary powers on this matter. Which means when a mercy petition is filed before the President of India, President will refer this matter to the Union Cabinet. Tell me what is it that I have to do on this matter. And whatever advice is given by the by the Cabinet to the President, President is bound by that advice. But the President or the convict cannot insist on oral hearing, which means when I'm filing a mercy petition before the president, I cannot insist that the president should give me audience. I can personally visit the president and explain the reason why he should grant me pardon. That's not a right available to the convict. Once this power is exercised, there can be judicial review on the grounds of mala fide. Which means if the president has exercised this power with bad faith on the advice of the Union Cabinet, judiciary can review the pardoning power of the president. Similarly, can use power to change the sentence and take evidence and take a different view. President, while exercising this power, may ask the evidence to be placed in front of him. On what evidence was this individual convicted? And basis this evidence, he may take a different view, completely different view from that of the court, and say, no, you are not guilty. We are setting you free. You are pardoned. But why these powers are available with the president or the governor? For that, we need to first understand what is the difference between the pardoning powers of the president under Article 72 and pardoning powers of the governor under Article 161. President's pardoning power extends throughout India, which means no matter where I have committed this crime, I can approach the President of India. But the governor's pardoning power extends within the state, which means if I've committed a crime in Tamil Nadu, to grant me pardon or reprieve or respite, whatever it is, I can only approach the governor of Tamil Nadu. I cannot approach the governor of Andhra Pradesh because I've committed the crime in Tamil Nadu. Which means the president's pardoning power extends throughout the territory of India. Governor's pardoning power extends only within the state. Only president can pardon death sentence. Governor cannot pardon a death sentence. But sir, recently there was a news related to Tamil Nadu that now governor can pardon a death sentence. That is misleading. That is untrue. I will tell you what is the real picture. But what governor can do, the governor can commute a death sentence. And you know the difference between pardon and commutation. Only the president has the power to pardon a convict who has been sentenced to death. Governor cannot pardon this individual. But what governor can do? Governor can commute that death sentence. And only president can pardon a person from the army who has been convicted under court martial. Governor cannot. Governor does not have this power to grant pardon to somebody who has been convicted in a court martial. That is the difference between the president and the governor. But what is this Tamil Nadu case? Can governor pardon a death sentence? Because if you Google search, governor can now pardon death sentence, you will see all newspapers will be publishing this news item. Governor can now pardon death sentence, but that is not correct. Why? First, you need to understand why this power has been given to the president or the governor. And listen to me carefully. Under Article 72, president has these powers. Under Article 161, governor has these powers. But these are not discretionary powers. They have to exercise this power only on the advice of the Union Cabinet. Clear? What are these powers? Pardon, commutation, respite, reprieve, remission. Clear? What's the difference between the two? Only president can pardon a death sentence, governor cannot. President's pardoning power extends throughout the territory of India. Governors extend only within that state. Only president can grant pardoning powers, can use pardoning powers for somebody who has been convicted in a court martial, whereas the governor cannot. But why these powers have been given to the president or the governor? One, to correct a judgment which is harsh. For example, Rahul Gandhi was convicted by a court in Surat on criminal defamation. First, let me be on the side of Mr. Rahul Gandhi. It should not come under criminal defamation. That's my take on this matter. Because if you're saying why are all Modi's thieves, or why are all thieves with the surname Modi? You are not defaming an entire class. That's not the point here. And the petitioner who approached the Surat court, it is argued in various newspaper reports that his caste is not Modi. So how can you approach the court and claim that I have been defamed? Because an individual cannot be looked into as a class. So I disagree with this judgment. But even if he was convicted, let's assume he did defame. But did he deserve a 2-year punishment? Why not? 2 years is the maximum punishment under criminal defamation. Maximum punishment. So whenever you commit a crime, or whenever this accused is brought before the court, if the court declares you guilty, but the court does not always give you the maximum punishment, because I will look at your background. It's not that you are from Gandhi family or your mother is Sonia Gandhi, that is your background. No, the background is you have never been a criminal. The background is, even if you're convicted today, this is going to be your first conviction. That means it's going to be your first crime. And you are the representative of the people. If I give you maximum punishment, what will happen to those voters who voted for you in Wayanad? Because the moment I give you maximum punishment, you are disqualified, which means 2 years or more punishment, you are disqualified. So I may not give you maximum punishment. I will give you 6 months punishment or 1 year punishment, but not 2 years. But what if Surat court says, no, you are guilty, maximum punishment is awarded to you? I think it is harsh. Matter went to the Gujarat High Court. Gujarat High Court said the same thing. I think it is harsh. What if Supreme Court also says the same thing? I think it is harsh. Mr. Rahul Gandhi can approach the president. The president will look at this case on the advice of the cabinet and ultimately decide, no, this is a harsh judgment. We are pardoning you, or we are commuting your sentence. Although it may not happen in Rahul Gandhi's case, because When this matter would be presented before President Murmu, she would say, "But your party did not vote for me." Or even if you voted, "But see, my dear, you are very sweet, but I cannot help you because I have to send this matter to, you know whom? Home Minister. Home Minister will organize a cabinet meeting. There they will discuss, and whatever advice they give me, that is binding on me. So, my child, I cannot help you here." But forget about Rahul Gandhi. If there is someone else who was given harsh sentence by the judiciary, the power is given to the president or the governor to correct this harsh judgment. That's reason number one. Reason number two, we have terrorism in Jammu and Kashmir, separatism. There are various organizations who want Jammu and Kashmir to merge with Pakistan or to stay independent. Some organizations, they don't want to be part of India. But that is what diplomacy is. You have to convince those who don't want to be part of you so that they can also be part of you. They want to be part of you. This is where it involves give and take. And this has been happening repeatedly. In Punjab also, there was insurgency. In Northeast, there is insurgency. What if, for example, let's skip Jammu and Kashmir, take a look at Nagaland. There are various organizations who do not want to be part of India. NSC, IN, for example, Muthawa faction, so many insurgent groups in Nagaland. You will discuss that in internal security. What if tomorrow, and there was also newspaper reports few years ago which said, finally we have a Nagaland Accord. Finally, we have a solution to this problem in Nagaland. And some newspaper reports said maybe Nagaland will have a separate flag. Maybe Nagaland will have a separate constitution. What exactly is that accord? We don't know. Nobody knows. That's the matter between the government and these insurgent groups. But what if tomorrow these Naga groups, they will lay down arms and will join Union of India, will ensure that there is peace in Nagaland. But previously, before this accord, they were terrorists. They had committed crimes. They had committed murders. They had waged war against the country. What if against their leaders, there are cases already pending before the court? Court will not look into whether you have a treaty with the government, whether you have an agreement with the government. Court will look into evidence. Not who you are, but what is the evidence against you. And the evidence against you, you have waged war against the country. And for that, I will sentence you to death. So the leader of a Naga group who held talks with the government, for example, this leader of the Naga group was sentenced to death. Now he is in jail. And inside the jail, now the government officers, some diplomats, they approach him and say, "We will save you. You just have to tell your cadre to lay down arms, join Union of India, sign the ceasefire, sign the treaty, so that from now onwards you will never claim Nagaland as a separate country or a separate state." This convicted individual, who is the leader of a group, is now signing an agreement in return for pardon. The president will pardon this individual. You are now set free, and not only set free, you are free from all the disqualifications. That means the moment you step out of jail, you can contest the election. You might think this is wrong, but this is diplomacy. This is how you win peace. There has to be an element of give and take. You can't always take and not give anything. These are the reasons why pardoning powers are available with the president or the governor. But what about Tamil Nadu case? Rajiv Gandhi was assassinated. The year was 1991 in Tamil Nadu. Then there was an investigation and it was found that LTTE, Liberation Tigers of Tamil Eelam, a separatist group in Tamil Nadu, who want a separate country for Tamils in the northern and eastern part of Sri Lanka. Why? Because their language was discriminated. These minorities were discriminated. But then in 1987, Indian Army sent peacekeeping troops to Sri Lanka, which LTTE did not agree. LTTE thought that now Indian government, which had to support us, is now supporting the Sri Lankan government. And they planned this attack, and Rajiv Gandhi, in a suicide mission, was assassinated. And there were many individuals who were arrested. Nalini was arrested. So many other individuals were arrested. Pirari Valan was arrested. Now, Sonia Gandhi, along with his daughter, they meet Nalini in jail. Nalini, who was one of the convicts in this case, she was pregnant. And then on the recommendation, on the request of Sonia Gandhi, her death sentence was commuted. But that's not the point. The point is, undue delay in disposing mercy petition. What is this undue delay? I am convicted by the court. I approach the President of India. Please grant me mercy. Please accept my mercy petition. I send this matter as the President to the Union Cabinet. Union Cabinet, even if it gives advice or does not give advice, but I am not acting on this mercy petition. That means this mercy petition is pending. The killers of Byan Singh, the Chief Minister of Punjab, mercy petition pending. Rajauna, mercy petition pending. So many mercy petitions were pending. Then Afzal Guru's mercy petition was pending. Afzal Guru, who was convicted in Parliament attack case of 2001, he filed a mercy petition in 2006 and it was pending. The BJP, which was in the opposition at that time, accused the Congress of being soft on terror. That is why you are not hanging Afzal Guru despite the fact that Supreme Court has convicted him. Why are you saving him? Why don't you reject his mercy petition? The government said Afzal Guru's mercy petition is at a different serial number. First, we have to dispose of other petitions which are pending. Then Afzal Guru's case will come up. Then came 26/11 attacks on Mumbai. Ajmal Amir Kasab was arrested, alive, and then he was prosecuted. He was sentenced to death. He also filed mercy petition. But his mercy petition was rejected by the then President of India, Pranab Mukherjee, on the advice of the cabinet, and he was hanged. Then the BJP said, how come now Ajmal Kasab, who was last on the list of the mercy petition, suddenly he is hanged, but Afzal Guru is saved? Then in February 2013, Afzal Guru was also hanged. But when he was hanged in secrecy. That means after his hanging, his family was involved. His family was informed. Media was informed. Matter went to the court. Shatrughan Singh Chauhan versus Union of India, 2014. And it was this judgment which humanized death penalty. Humanized in the sense, number one, inform family 14 days before hanging. Give opportunity to the family to meet convict. Those suffering from mental illness shall not be hanged. And wherever there is inordinate delay, in disposing of mercy petitions, commutation will take place. Supreme Court in 2014 in Shatrughan Singh Chauhan versus Union of India said, if there is a convict who is suffering from mental illness, schizophrenia, for example, this person cannot be hanged. Whenever you have to hang an individual, give him the opportunity, give him a notice, and after 14 days, you can hang this individual. Because in this 14-day period, he will make peace with his God. Maybe he want to apologize to God or some other individuals. He want to seek penance for what he has done. Within this 14-day period, you have to inform his family as well and set up a meeting of this convict with the family. so that he can bid them a final goodbye. And that is how, after 14-day period, you can hang this convict. But if there is an inordinate delay means delay which you can't explain. Why this delay? Why are you late for the class? There was traffic. Oh, you are from Bengaluru. Except, why are you late? The class is in a village where there is no traffic. You can't explain why you are late. Inordinate delay. If the mercy petition is filed before the president, but there is a delay in disposing of this mercy petition, the president is not saying mercy petition is accepted or rejected, and he's not able to explain also why this delay, then this death sentence will be commuted to life imprisonment. In Tamil Nadu case, when these individuals were arrested, when they were sentenced to death, after that the Supreme Court had commuted their death sentence. That means now they are not death sentence convicts, they are under life imprisonment. Chief Minister and Cabinet of Tamil Nadu is advising the governor to set convict free. In the Rajiv Gandhi case, when your death sentence has been commuted to life imprisonment, that means now this individual is under life imprisonment. Can governor commute life imprisonment? Yes. Can governor pardon a life sentence? Yes. That means if you are under life imprisonment and if you are under death sentence, can governor pardon a death sentence? No. Can governor pardon a life imprisonment? Yes. Which means you will be set free. Chief Minister and the Cabinet of Tamil Nadu advising the governor, please set Pirari Valan and others free. Governor says, I will not do it. Why? Number one, this convict was booked under the central law. So there was an investigation done by the central agency. So if at all he is to be set free or not, for that I will have to take the advice of the president. I have to reserve this matter to the consideration of the president, because this individual was convicted under a central law and this individual was investigated by our central agency. Question number 2. For example, there is a convict who is sentenced for a crime for which death sentence is an option. But this convict was given life imprisonment. For example, I have waged war against the country, for which what is the maximum sentence? Death. But when my matter reached the court did not grant me death sentence, did not grant me the maximum punishment which was available under this offense, but instead granted me life imprisonment. That means for this crime, death sentence was an option, but death sentence was not given, life imprisonment was given. According to Criminal Procedure Code, unless and until I serve mandatory 14 years, I am not available and eligible for remission. What does that mean? What is life imprisonment normally? Sometimes the court says, for you, you will remain in jail for the normal life of an individual, which means throughout your life, you will remain in jail, you will never be set free. Or if you are told that you are given life imprisonment, but that does not mean you will remain in jail forever if it is not for the normal life of an individual. If it's a simple life imprisonment, after 14 years, there will be a committee set up in the jail. Here is a convict. He was awarded life imprisonment. Not the life imprisonment for his entire life, but simple life imprisonment. And then he is in jail. He is in prison. Once he serves 14 years, there will be a committee set up, the prison committee, and they will look at his condition. They will look at his conduct throughout these years. And if they feel that he is good, he has reformed, because jails, prisons are after all for your reform. That's the golden rule of a criminal justice system. Criminal justice system's goal is to give punishment so that it can deter others from committing crime, and give punishment so that you can reform this individual. Your parents are giving you punishment, but not because they hate you, because they want to reform you if you have done something wrong. So if this individual was in the jail for 14 years, he was given life imprisonment, but after 14 years, there will be a review whether this individual has reformed or not, whether he is doing good or not, whether he can be an asset to the society or not, whether if we set him free, whether he will be able to live the life of a normal individual or not. If yes, we will remit his crime, we will remit his sentence, we will release him. But previously, Criminal Procedure Code said, if you were given life imprisonment, unless and until you mandatorily serve 14 years, you will not be eligible for early release. That's what we call remission. You will not be eligible for early release. In Tamil Nadu case, there were individuals who were given life imprisonment for crimes for which death sentence was an option. The governor of Tamil Nadu said, I cannot release these individuals because I cannot pardon a death sentence. Chief Minister and his cabinet is saying, but you are not pardoning because they were not given death sentence. So this is not a death sentence case. Governor said no. Matter went to the Supreme Court finally. And Supreme Court said, under Article 161 of the Constitution, the governor has the power, only on the advice of the cabinet of that state, chief minister and his cabinet, that you can pardon an individual who was convicted for a crime for which he was not given death sentence, but death sentence was an option. Instead, he was given life imprisonment. You don't have to necessarily serve 14 years, after which only you can be released. You can be released even before serving these 14 years. That means if you are an individual who has been convicted for a crime for which death sentence was an option, but you were not given death sentence, you were given life imprisonment. For that, you don't have to mandatorily serve 14 years in jail, after which you can be released. You can be pardoned at any point in time by the governor under Article 161 of the Constitution, only on the advice of the Chief Minister and Cabinet. And that is how newspapers misleadingly wrote the headline, Governor can now pardon a death sentence. Governor can pardon a convict who was convicted for a crime for which death sentence was an option but was not given. Instead, life imprisonment was given. And without serving mandatory 14 years, you can be pardoned. That is the position of the Supreme Court on Tamil Nadu case. And that is how later on Pirarivalan and others were released. That is the pardoning power of the president and the governor under Article 72 and 161. Can governor commute a death sentence? Yes. Sir, I can't see previous videos. Maybe there is a technical glitch. We have received some complaints from the students as well. But today we will be able to sort this out. Please don't worry. Recordings have not disappeared. There is some technical issue. We are working on it. We will resolve it. And you will be given access to those recordings again. Please do not worry. Okay. Now let's look at prelims-based questions one by one. This question was asked in 2017. Local self-government can be best explained as an exercise in 3 seconds to go. Laksh previously used to be at rank 1, but now maybe has taken extra time to answer. Local self government can be best explained as an exercise in democratic decentralization. Balwant Rai Ji Mehta recommended in 1958 that there should be democratic decentralization. That means create a three-tier structure in local government and empower them with powers so that these institutions emerge as the units of rural local self-government. So local self-government is an exercise not of federalism, not of administrative delegation, because this delegation is not given by administration. In fact, it's distribution of powers, not delegation. Not direct democracy, because not all people are participating in these exercises, but democratic decentralization. 2016, the minimum age prescribed for any person to be a member of Panchayat is 25. Panchayat reconstituted after premature dissolution continues only for the remainder period. Okay. 57% students are right. The minimum age prescribed for any person to be a member of Panchayat is 25 years. If you are qualified to contest legislative assembly elections, you are qualified to contest Panchayat elections as well, with one difference: age. If you are 21 years old, you can contest Panchayati Raj elections. That means this statement is incorrect. The Panchayat reconstituted after the premature dissolution continues only for the remainder period. Correct? Because the term of the Panchayat is 5 years. If it is dissolved prematurely, which means let's say after 1 year, and then fresh election is conducted, this new Panchayat which was constituted will remain for the remainder of the period. Correct? So which of the statements are correct? B, 2 only. This question was asked in 2019 with reference to the Constitution of India. Consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. An amendment to the Constitution of India cannot be called into question by the Supreme Court. Which of these statements are correct? Take the answer. Why are not all, why are you not attempting these questions? Even if you are wrong, but please attempt. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Incorrect. Because I told you, High Courts can hear all kinds of cases: fundamental rights violation cases, constitutional cases, challenge to the central laws. Any case can be heard by the High Court. An amendment to the Constitution cannot be called into question by the Supreme Court. This you would know is incorrect, because a constitutional amendment is challenged before the Supreme Court. 99 Constitutional Amendment Act, NJAC, was declared unconstitutional by the judiciary. Recent amendment, 103rd Amendment to the Constitution, it was challenged before the court, EWS reservation. So constitutional amendments are called into question by the Supreme Court. Neither one nor two is the right answer. This question was asked in 2019. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? The decisions taken by Election Commission while discharging the duties cannot be challenged in any court of law. The Supreme Court of India is not constrained in the exercise of its powers made by laws passed by the Parliament. In the event of grave financial crisis, the President can declare financial emergency. State legislatures cannot make laws on certain matters without the concurrence of the state of the Union government. What is the right answer? Why are students confused between A and C? Under Article 142, Supreme Court can give any order so as to give complete justice. So even if you do not remember what is this complete justice, you at least will have to remember that Article 142, when we discussed in the class, sir talked about judiciary. So it is not about election commission. It's not about financial emergency. It is not about state legislatures cannot make a law. It is about Supreme Court. Supreme Court is not constrained, is not limited by the power, by the laws passed by the parliament. It can do anything so as to give complete justice. That's Article 142. Sir, why aren't the previous classes accessible? My dear, I told you previously, there is some technical issue, some technical glitch. We are working on this. Will be resolved today, hopefully. You will regain access to those classes. Don't worry. Okay. Consider the following statements. The motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per Judges Inquiry Act 1968. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. The details of the process of impeachment are given under the Judges Inquiry Act 1968. If the motion for the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by the majority of that house and not by less than two-thirds of the total members of the house present and voting. Which of these statements given above are correct? And I will give you 30 seconds to answer this question. And even if you are wrong, but please attempt it. Sir, Lakshmikant, important chapters. My dear, I can't do two things at the same time. On one hand, discussing previous year's questions, and on the other hand, discussing the important chapters of Lakshmikant. We will discuss these previous year's question papers, then we will jump to the important chapters of Lakshmikant. Patience is a virtue. This is our leaderboard. The motion to impeach a judge of the Supreme Court. Sir, you said we use the term impeachment only for the President of India. Then why is UPSC using this term for the judge of the Supreme Court? UPSC is wrong. And UPSC has made mistakes in some of its questions in the past. It will make mistakes tomorrow as well. So hold UPSC accountable, not me. I have to tell you the real picture. Impeachment is a term used only and only for the president by the Constitution. The motion to impeach a judge of the Supreme Court cannot be rejected. It can be. Justice Deepak Misra case. Motion was sent by the Rajya Sabha MPs to the chairperson, the speaker of the presiding officer of the Rajya Sabha. He rejected it. So it can be rejected. The Constitution of India defines and gives details. Constitution only says the judge of the Supreme Court and High Court can be removed by the president on the recommendations of the parliament when the parliament passes a resolution by two-thirds of the members present and voting and by majority of the total membership of the house on the grounds of proved misbehavior and incapacity. But what is this proved misbehavior? What is this incapacity? It is not defined in the Constitution. For that, we have a law passed by the parliament known as the Judges Inquiry Act of 1968. The details of the process of impeachment of the judges are given in Judges Inquiry Act, correct? Process is not mentioned in the Constitution. Is it mentioned in the Constitution? No. Where is it mentioned? Just Judges Inquiry Act. That means if you are from Rajya Sabha, 50 MPs will have to write to the chairperson. If you are from Lok Sabha, 100 MPs will have to write to the speaker. Then if the speaker accepts, there will be a 3-member committee. 3-member committee will submit a report. Judge will be given an opportunity to present his side of the story. This entire process is mentioned under Judges Inquiry Act. And once basis this report, when this motion is to be taken up for voting, if both Lok Sabha and Rajya Sabha pass a resolution by majority of the total membership of the House, which is absolute majority, and by not less than 2/3 of the members present and voting, the judge is removed. So 3 and 4, C is the right answer. 2017 question. In India, judicial review implies the power of the judiciary to pronounce upon the constitutionality of laws and executive orders, the power of the judiciary to question the wisdom of the laws enacted by the legislatures, the power of the judiciary to review all enactments before they are assented to by the president, the power of the judiciary to review its own judgments given earlier in similar or different cases. 30 seconds. Tell me what is the right answer. Sir, please assure us that previous live classes will be viewed. 100%, my dear. Otherwise, we would not have started this initiative. Why would we do that? Don't worry. 46% students. In India, judicial review implies what? Is it power? And whenever you are confused about options, first eliminate the wrong ones. The power of judiciary to review all legislative enactments before they are assented to by the president? No. There have been instances where people have approached the judiciary even before the laws were passed by the parliament, saying these laws are unconstitutional, this bill is unconstitutional. The Supreme Court has said you cannot question the validity of a bill inside the judiciary. You can question the validity of a law. That means we don't know whether this bill will be passed by the parliament or not, then signed by the president or not. So if you are talking about hypothetical situation, this bill is unconstitutional. This is a hypothetical situation. What if this bill is changed by the parliament, not signed by the president? We are wasting our time. First, let the bill be passed, then signed by the president. Once signed by the president, you can approach us challenging the validity of this law. So not before they are assented to by the president, after they are assented by the president. The power of judiciary to question the wisdom of the laws, that's not what judicial review is. You cannot question the wisdom of the parliament. The power of judiciary to review its own judgment. Yes, that is review judgment. That is the revisory jurisdiction of the court. That's the power of the court. But in reality, if the question is asking you in India, what does it mean? And if there are two statements which it appears are correct, you have to pick the most appropriate answer. And the most appropriate answer is power of the judiciary to pronounce upon the constitutionality of the laws as well as executive actions. 122 2G licenses cancelled, judicial review. NJAC, unconstitutional, judicial review. So legislature actions as well as executive actions. That's what judicial review is. And that is why A is the right answer. 2014, and this has to be correct. If you will not mark this question correct, I'm leaving. The power to increase the number of judges in the Supreme Court of India is vested in. Sir, but due process of law includes questioning wisdom of the parliament. It's not basically questioning the wisdom of the parliament. It's basically questioning the fairness of the law. The law has to be fair. The procedures have to be reasonable without getting into the intention of the law. Although in due process of law, court can even do that, but we don't say it explicitly. We say we follow procedure established by law, which also includes that laws have to be fair. I was knowing this. Even then, some of the students are wrong. The power to increase the number of judges in the High Court is given to the president. Every High Court will consist of Chief Justice and as many judges as determined by the president. Power to increase the number of judges is given to the parliament. The parliament has increased the number of judges, and this is something we discuss explicitly. Parliament can enact an ordinary law to increase the number of judges. That is how today we have a Chief Justice and 33 other judges. And I told you, this law shall not be deemed as amendment to the Constitution. That means although you are amending the Constitution, but you are doing this through an ordinary law by simple majority. So even if you are confused, you should still go back to these lectures in your mind. Well, while discussing increase in the number of judges or judges appointment, did sir said something about president or the parliament? Okay. 2014, the power. Now this is as easy as it can get. 15 seconds. The power of the Supreme Court of India to decide disputes between the center and the states falls under its advisory, appellate, original, writ. Original jurisdiction. The Supreme Court has original jurisdiction in cases which are federal in character, involving disputes between the center and the states. This is the easiest question ever asked in the history of UPSC exam. Please, patience. Read the question carefully. Mark it correctly. Correctly in the sense, read it, understand it, then mark it. But sir, you are giving 15 seconds only because this is the easiest question. Okay, now let's see what you will do here. Right to vote, I will increase the time. Right to vote and to be elected in India is a fundamental, natural, constitutional, legal right. My God. 10% students say A. When did I say right to vote is a fundamental right? Is it under Part 3 of the Constitution? Right to vote, my dear, Article 326. Where is it mentioned under Part 3 of the Constitution? So it is clearly not a fundamental right. It's not a natural right under Article 19 because all the rights under Article 19 are natural rights. It is a legal right provided by the Constitution. But the most appropriate answer is that it's a constitutional right under Article 326. Okay. In an election for the Lok Sabha or state assembly, the winning candidate must get at least 50% of the votes polled to be declared winner. According to the provisions laid down in the Constitution of India, in Lok Sabha, the speaker's post goes to the majority party and the deputy speakers to the opposition. Which of the statements given above are correct? And for this, I will give you 1 minute. Sir, in Google, it shows that motion to impeach a judge of Supreme Court cannot be rejected. Well, Google in that case is wrong, but it should not be Google. Google only gives you searches. Check the website which has given that information. That website is wrong. Even if multiple websites display that information, that doesn't change the fact that they are wrong. And I've given you explanation as well. Justice Deepak Misra, the motion to remove him was rejected. Okay, 63% students are right. Laksh again is top. His Laksh is clear. In the election for Lok Sabha or state assembly, winning candidate must get at least 50%. But we follow first past the post system, where you don't necessarily have to get the majority. You just need to get the highest number of votes. Incorrect. According to the provisions laid down in the Constitution, no. This is a convention, unwritten rule, something that is decided by political parties themselves, that the speaker's post will be given to the ruling party or the ruling coalition, and the deputy speakers will go to the opposition. But this is not mentioned in the Constitution. Constitution only says that after the Lok Sabha is convened, as soon as may be, the House shall elect two of its members as the speaker and the deputy speaker. It does not say that speaker has to be from the ruling party and the deputy speaker from the opposition. So both these statements are incorrect. Neither one nor two is the right answer. 2016, the Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by Lok Sabha by simple majority, Lok Sabha by two-third majority, Rajya Sabha by simple majority, Rajya Sabha by two-third majority. Such a simple question, which I'm sure is not simple for you. Twenty, 30, 40, 46, 52, 55% students are wrong. Parliament of India acquires the power to legislate on any item in the state list. We are talking about Article 249, which I told you is one of the special powers of the Rajya Sabha, where only if Rajya Sabha passes a resolution by the majority of not less than two-thirds of the members present and voting, only then Parliament can legislate on any item in the state list in national interest. So D is the right answer. Question number, and this question was asked in 2019. Which one of the following suggested that the governor should be an eminent person from the outside of the state and should be a detached figure without intense political links or should not have taken part in politics in the recent past? Was it the first Administrative Reforms Commission, Rajamanar Commission, Sarkaria Commission, National Commission to review the working of the Constitution? Simple question, 15 seconds. Tell me the right answer. It is the chairperson of Rajya Sabha who rejected Justice Deepak Mishra's case, right? But under the constitution, and we have discussed that if you have attended the class, Judges Inquiry Act says the presiding officer may accept or reject that petition. Presiding officer includes speaker. 76% students are right. It is the Sarkaria Commission of 1983. Very good. This question was asked in 2021. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. Whenever you read such statements, underline the important points. In India, there is no law restricting the candidates in one Lok Sabha election from 3 constituencies. In 1991 Lok Sabha election, Shri Devilal contested from 3 Lok Sabha constituencies. As per the existing rule, if a candidate contests in one Lok Sabha election from many constituencies, his party should bear the cost of by-elections to the constituencies vacated by him in the event of him winning in all the constituencies. Which of the given statements above are correct? I will give you 1 minute to answer this question. See if you can eliminate some options, and even if you don't know the statement whether it is correct or incorrect, maybe you can eliminate some options and reach to a conclusion. Ten seconds to go. Yes, Laksh, mostly extreme statements are wrong. 49% students are right. Let's see. In India, there is no law restricting the candidates from contesting in Lok Sabha election from 3 constituencies. Incorrect. There is a law. What is that law? Representation of the People Act 1951. Yesterday we discussed one election reform, one electoral reform, that today Representation of the People Act allows a candidate to contest election from up to 2 constituencies. And the reform we proposed was that candidates should be allowed to contest election from only 1 constituency, not up to 2. So first statement is clearly wrong. Second statement, I don't know. As a student, you would say, I don't know. How can I remember all of this? Devilal, whether he contested from 3 or 6, how do I know? Let's leave it. And please understand, whenever such statements are given in the question, you should assume that UPSC is trying to mislead you. Even if you don't know the answer to this question, even if you don't know whether the statement is correct or incorrect, it is immaterial. You can still give the right answer. You don't need to know whether the statement is correct or not. You can still give the right answer. Play with UPSC. How? As per the existing rules, if a candidate incorrect, clearly incorrect. Why? Mr. Modi contested from Vadodara as well as Varanasi. And then after the election, he had to give up 1 seat. He gave up Vadodara. That means fresh election was to be conducted here. But political parties do not bear the cost of re-election or by-election. And I told you the very reason why we are saying that candidates should be allowed to contest from only 1 constituency is that it is like harassing the voter to vote again in the same constituency. And it wastes a lot of time. That means same amount of money is to be spent again. This is public money. Political parties do not contribute for by-election. So this statement is clearly incorrect. So 1 and 3 is clearly incorrect. This cannot be the option. This cannot be the option. This cannot be the option. So the only answer left is B. 2 only. But sir, isn't it contradictory? You said Representation of the People Act says that you can contest election from only up to 2 constituencies. And now how can Devi Lal contest election from 3 constituencies? This is in 1991. The law was amended in 1996. But sir, how do I remember whether this law was amended in 96 or not, before 91 or not? At least you can eliminate 1 and 3. Both these things we have discussed. 1 and 3 is wrong. That means the only other option is left is 2. B only. B is the right answer. Okay. This question was asked in 2015. The Legislative Council of a state in India can be larger in size than half of the Legislative Assembly of that particular state. The governor of a state nominates the chairman of the Legislative Council of that particular state. Which of the statements given above are correct? 30 seconds. What's the right answer? Since BSP nowadays neither gets seats nor votes, then why its national party status has not been struck down? It does get votes, but those votes do not translate into seats. And it has a presence in Chhattisgarh, in Madhya Pradesh, in Rajasthan. In Rajasthan, they had 6 MLAs. But it's another question that all these 6 MLAs joined the Congress. 54% students are right. Laksh continues to have his Laksh clear. Legislative Council of a state can be larger in size than 1/3 of the Legislative Assembly, not half. So this is incorrect. The governor of a state nominates the chairman. No, this person is elected from amongst the MLCs. All the MLCs, they will get together, elect the chairperson and deputy chairperson by simple majority. And they can be removed by effective majority as well. That's something that we have discussed. So D, neither 1 nor 2 is the right answer. 2014, which of the following are the discretionary powers given to the governor? There shall be Council of Ministers with Chief Minister at the head to aid and advise the governor, who shall act on that advice except when the governor has to act in his discretion. But these discretionary powers are not mentioned in the Constitution. But then which are these discretionary powers? Sending a report to the president for imposing the president's rule, appointing the ministers, reserving certain bills passed by the state legislature for the consideration of the president, making the rules to conduct the business of the state. Please attempt, all of you, even if you're wrong, but attempt. Ten seconds to go. Manpreet, what's your question? 68% students are right. Okay. Will governor send a report to the president telling the president, please dismiss the government and impose president's rule in the state on the advice of the chief minister? No. So this has to be discretionary power of the governor. Appointing of ministers. Appointing a chief minister is a discretionary power. But all ministers are appointed by the governor only on the advice of the chief minister. So this is incorrect. Reserving bills passed by state legislature for consideration of the President of India. What is the matter between the governor of Telangana and the government of Telangana? Same is the case in Tamil Nadu. Same is the case in Punjab. If you read today's Indian Express newspaper, on page number 1, you will see that Supreme Court is saying that only when the matter reaches the court, that is when the governor decides to take action on a bill. The governor should decide on these bills before these matters reach to the court. The governor will have to do some soul searching. That's what Supreme Court said. Soul searching, because you are not elected by the people. One point of contention between the government and the governor is that you are reserving bills for the consideration of the president. That is the discretionary. Otherwise, why would a chief minister ask the governor, reserve this bill for the consideration of the president? So this is a discretionary power. Making rules to conduct business of the state government, this is not the discretionary power. How the business is conducted, how many ministries are to be created, who gets to be allocated portfolio of a particular department, that is not the discretionary power of the governor. That is under the advice of the chief minister and council of ministers. So which of the statements are correct? 1 and 3. B is the right answer. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, we are talking about President's rule under Article 356, then the assembly of that state is automatically dissolved. The powers of the legislature of that state shall be exercisable by or under the authority of the parliament. Article 19 is suspended in that state. The president can make laws relating to that state. Simple question, 30 seconds for you. What is the right answer? Laksh, we will be starting prelims test series in December. So take those tests, and you can also find lots of MCQs on the app. Practice more. QT pi is at 160. If the President of India exercises his power as provided under Article 356 of the Constitution, then assembly of that state is automatically dissolved. What did I tell you about SR Bommai judgment? That president's rule, when it is invoked in a state, the Supreme Court has said don't dissolve the legislative assembly unless and until both houses of the state parliament approve this president's rule. Even if you have not read this, look at the reality, look at current affairs, try and find out answers from the newspaper reading. Where was president's rule imposed recently? Maharashtra. Why? Because Shiv Sena, BJP, they parted ways, they could not form the government. No government was possible, president's rule was imposed. But then this president's rule was also revoked. Did a fresh election take place? No. That means if there was no fresh election, that means the same legislature continued. Which means legislative assembly is not automatically dissolved. It is kept under suspended animation. It is suspended. And when these MLAs, they are able to form the government, then this assembly is revived. And from this assembly, we choose the chief minister and the ministers, and they continue. It is only when no government is possible, then the governor has no other option but to dissolve the legislative assembly. But it is not automatically dissolved. It's not that as soon as you impose president's rule, legislative assembly is dissolved. No. As soon as you impose president's rule, chief minister is dismissed. Council of ministers are gone. Not the legislative assembly. Incorrect. Article 19 is suspended in that state. Article 19 has nothing to do with president's rule. Article 19's enforcement is suspended automatically when national emergency on the grounds of war or external aggression is imposed. Fundamental rights have no bearing when it comes to president's rule. The president can make laws relating to that state, but president is a part of the executive. How can he make laws for that state? No. Article 356 says when the president proclaims president's rule, in its presidential proclamation, it says, all the executive powers of the state will be with me, I am the president. All the legislative powers will be with the parliament. That's how during president's rule, parliament makes laws for that state. When national emergency is imposed, then is the state assembly automatically dissolved? No. And we discussed that during national emergency, in fact, the life of the legislative assembly is extended 1 year at a time. Okay. 2017, which of the following are not necessarily the consequences of the proclamation of the president's rule in a state? Not necessarily. That means as soon as president's rule is imposed, these things may not happen necessarily. Dissolution of the state assembly, removal of the council of ministers, dissolution of the local bodies. What is the right answer? Simple question. I'll still give you 30 seconds. My God. 41% students are right. Which of the following are not necessarily? As soon as president's rule is imposed, removal of council of ministers in the state, this is necessity. The first casualty is the chief minister and council of ministers are dismissed, removed. But can legislative assembly be dissolved? Not necessarily. And there is no impact of president's rule on local bodies. There is an impact on state government because of president's rule. Panchayati Raj institutions continue. Municipalities continue, even if there is a president's rule. 1 and 3 is the right answer. The provisions in 5th and 6th schedule of the Constitution of India are made in order to protect the interest of scheduled tribes, determine the boundaries between states, determine the powers, authority, and responsibilities of panchayats to protect the interest of all the border states. This is very simple. I'll give you 15 seconds because I've taken 10 seconds to read this question. Wow, 88% students are correct. Very good. To protect the interest of scheduled tribes. 5th schedule deals with states other than Assam, Meghalaya, Mizoram, and Tripura. 6th schedule deals with the tribal areas in Assam, Meghalaya, Mizoram, and Tripura. In essence, what does due process of law mean? 30 seconds. What is the right answer? Do we have to study, memorize objectives of committees and commissions whose recommendations have more or less been accepted and implemented by the government? Or should we study the reports of those committees and commissions whose recommendations are not yet accepted and are pending from a long time? Anything. All the things. Even if there is a committee report which has not been accepted, can be asked in the exam. Which has been accepted, can be asked in the exam. But mostly you should look at those committees which are in the news and focus on them. Oh, Laksh has given a wrong answer. I think, for this particular question. In essence, what does due process of law mean? Does it mean procedure established by law? No, because under Article 21 of the Constitution, the state shall not deprive an individual of his right to life and personal liberty except according to procedure established by law. But the Supreme Court has said we follow due process of law, which means due process of law is different from procedure established by law. That means B cannot be the answer. D cannot be the answer because it talks about equality before law, and equality before law is under Article 14 of the Constitution, not under Article 21. Now the question is fair application of law or principles of natural justice. Let's say even if we were following procedure established by law, if you have been arrested, Article 21 has been violated, you assume Article 21 has been violated, you will go to the court. How will court set you free? After performing 3 tests. Test number 1, is there a law which justifies your arrest? Test number 2, is this law valid? Test number 3, are the procedures mentioned in the law followed or not? If procedures are not followed, you will be set free. That means if this law is not fairly applied, you will be set free. So procedure established by law includes fair application of law. That means even if we were following procedure established by law, that doesn't mean you can apply this law unfairly. Even there, you have to apply this law fairly. Which means the answer is principle of natural justice. And what is this principle of natural justice? 4th test will be prescribed by the court in due process of law. Is this law reasonable? Are the procedures fair or not? Which means the Supreme Court in its 4th test will look into the intention of the parliament, the wisdom of the parliament, whether it has passed a good law, correct law or not. That is what principle of natural justice is. The authority shall act bona fide, which means when the legislature is making a law, its intention should be good. It must act in the good faith. So the answer to this question is the principle of natural justice. Okay. Which one of the following statements best reflects the chief purpose of the constitution of a country? It determines the objective for the making of necessary laws. It enables the creation of political offices and a government. It defines and limits the powers of the government. It secures social justice, social equality, social security. 30 seconds. Which one of the following statements reflects the chief purpose of the constitution? What is the role of ad hoc judge? If I have to hear a case, I am the Chief Justice of India. I have to hear a constitutional case, that means involving 5 judges or more. But let's say I have to hear a review for which I need 9 judges, and I can't have 9 judges. I don't have 9 judges. I will appoint an ad hoc judge. 70% students are right. What is constitutionalism? Government should and must be restrained in its powers. And the legitimacy of the government depends upon whether it is observing those limitations or not. Constitution's very purpose is to give powers to the government and then also have positions in place, practices in place to restrict this government. So it defines and limits the powers of the government. That is the job of the Constitution. That is the chief purpose of the Constitution. C is the right answer. In India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of fundamental rights? First Amendment, 42nd Amendment, 44th Amendment, 86th Amendment. Tell me what is the right answer. 30 seconds. It was evident majority would go for 42nd Amendment. 86th Amendment deals with Article 21A, when right to free primary education for children in the age group of 6 to 14 was enacted. So it is not about 86th Amendment. It is not about 44th Amendment, because 44th Amendment was meant to undo the damage done to the Constitution by 42nd Amendment. Clear? First Amendment. Which one of the following constitutional amendments was widely believed to be enacted to overcome judicial interpretation of fundamental rights? The Land Reforms Act unconstitutional. Why? Because it violates 1931. Zamindari Abolition Act unconstitutional. Why? Because it violates 1931. There can be no reservation to SCs and STs in government engineering and medical colleges. Why? Because it violates Article 15 of the Constitution. Directive principles are inferior, fundamental rights are superior. How did the Parliament react to these judicial verdicts? By enacting the First Constitutional Amendment Act 1951. So the answer is First Constitutional Amendment Act. 42nd Amendment was done for a variety of reasons. 42nd Amendment was done for, let's say, giving primacy to DPSPs over fundamental rights, yes. But 42nd Amendment was also to impose restriction on the President of India. There shall be Council of Ministers with Prime Minister at its head to aid and advise the President, who shall act on that advice. This term, who shall act on that advice, was added by 42nd Amendment. First Constitutional Amendment, I told you how more reasonable restrictions were added to Article 19(1)(a), freedom of speech and expression. But in the interest of public order, your fundamental right to freedom of speech and expression can be restricted. Why? Because this was in response to the Ramesh judgment regarding that Bombay Mirror, that magazine, which was to be transported, which was to be distributed in Madras, which was coming from Bombay. And there was a ban imposed on this on the ground of public order. Supreme Court said, but this ban is unconstitutional. Ramesh Thapar case. Because there is no such ground as public order on the basis of which your freedom of speech and expression can be restricted. To overcome that, First Amendment was passed. Article 19, Clause 1, Clause A, restriction was imposed, and that restriction was public order. So it is First Constitutional Amendment Act 1951. Consider the following organizations, bodies in India: National Commission for Backward Classes, National Human Rights Commission, Law Commission, National Consumer Disputes Redressal Commission. How many of the above are constitutional bodies? 30 seconds. Tell me the right answer. Why 42nd Amendment is called mini constitution? Because major changes, large number of changes were made to the Constitution by 42nd Amendment. National Commission for Backward Classes, yes, it is a constitutional body created under 102nd Constitutional Amendment Act. National Human Rights Commission is a statutory body. created by the law passed by the Parliament, Protection of Human Rights Act 1993. It was under this law that NHRC was created. National Law Commission it is an extra constitutional, that means not mentioned in the constitution, non-statutory body. That means it is not even created by the act passed by the Parliament. Just like Niti Aayog. National Commission, Consumer Dispute Redressal Commission. It is a statutory body created by the law passed by the Parliament. So only one, A is the right answer. Consider the following statements. If the election of the President of India is declared void by the Supreme Court of India, all acts done by him or her in the performance of duties of his or her office of President before the date of decision become invalid. Election for the post of President can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. When a bill is presented to the President of India, the Constitution prescribes time limits within which he or she has to declare his assent. Which of the statements given above are correct? 1 minute. Tell me the right answer. Thirty seconds to go. Sarmad sir, since the delimitation exercise reduces the number of Lok Sabha seats for South Indian states and thereby lowers the representation of South Indian Lok Sabha as a whole, can their seats be increased in Rajya Sabha to somewhat neutralize the effect similar to the Senate of US where the strength is irrespective of the population? That won't solve anything. That won't assuage the concerns of the southern states. Why? Because Council of Ministers is not accountable to Rajya Sabha. It's accountable to Lok Sabha. And then these southern states will fear that they will never be able to form the government at the center, or they will never be able to play the role of controlling the government at the center. They have to be having solid presence in Lok Sabha. Krunal, Mahanti, Ashutosh. 3 left now. If the election of the President of India is declared void by the Supreme Court, all acts done by him previously become invalid. Incorrect. If I am elected as the President today, I am sworn in as the President, I take certain decisions. After 3 months, Supreme Court says your election is void because you were holding office of profit, now you are disqualified. Clear? Whatever actions I have done in these 3 months, they will not be invalid. They will have the same validity as they were given by the President. Election for the post of President can be postponed. Incorrect. There is Electoral College. And in this Electoral College, we have the elected members of Legislative Assembly, elected members of Lok Sabha, elected members of the Rajya Sabha. Clear? Elected members of the Union Territory legislatures as well, Legislative Assembly as well. For example, in a particular state, there is no Legislative Assembly. That means there is a vacancy in Electoral College. Can this vacancy be the ground that you can postpone the election of the President of India? No. Sir, how do I know this? J&K MLAs did not participate in President's election. Does that mean President's election was postponed? No. Previously also there is a Supreme Court judgment on this. In the Rajasthan, President's rule was imposed. Legislative Assembly later on was also dissolved. When there was no government, no Legislative Assembly could continue because they were not able to form the government. And there was a petition that President's election should be postponed because in Rajasthan we don't have MLAs. Supreme Court said just because there is a vacancy in Electoral College, that doesn't mean we have to postpone the election. Just like yesterday we discussed a committee that according to this bill which is pending in the Rajya Sabha, which talks about how Chief Election Commissioner and Election Commissioners are to be appointed, will be appointed by President based on the recommendation of a committee. Committee will consist of Prime Minister, Union Cabinet Minister, and the leader of the opposition or leader of the single largest party in Lok Sabha. But the same law says even if there is a vacancy in this committee, that doesn't mean the committee cannot send its recommendation. Vacancies don't matter. Election will not be postponed for that president. When a bill is presented to president, constitution prescribes time limit. You know this is incorrect. D, none of the above is the right answer. With reference to finance bill and money bill in the Indian Parliament, consider the following statements. When the Lok Sabha transmits finance bill to Rajya Sabha, it can amend or reject the bill. When the Lok Sabha transmits money bill to the Rajya Sabha, it cannot amend or reject the bill. It can only make recommendations. In case of disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for a finance bill. This is where UPSC again is wrong. Wrong in the sense, it should not have been finance bill. It should have been financial bill. On this particular question, if a student has given a right answer, he will get minus 0.67 marks. Why? Because although it is right according to you, UPSC will make it wrong. How? Let's assume this is financial bill and money bill, not finance bill and money bill. And then see what is the answer. And then see if it is indeed finance bill and money bill, then what is the answer. And then see why we should assume it is financial bill, not finance bill. Because if you will assume that it is financial bill, you will get 2 marks. If you will assume it is finance bill, you will lose marks. And that you will realize when the answer key will be presented by the UPSC. For this, we don't have an answer key yet. Assume it is financial bill. When Lok Sabha transmits financial bill to Rajya Sabha, it can amend or reject a bill. Financial bill can be introduced in Lok Sabha. Once it is passed, it can be sent to Rajya Sabha. Rajya Sabha can reject a financial bill. Rajya Sabha can amend a financial bill. Correct. When the Lok Sabha transmits money bill to Rajya Sabha, it cannot amend or reject the bill. It can make only recommendations. Correct. In case of disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for finance bill. In case there is a disagreement on money bill, once 14 days are over, Rajya Sabha assumes it has given permission to money bill, the bill is passed. But if it's a disagreement on a financial bill, President may notify joint sitting of the 2 houses, may notify. That means it is not necessary. It may notify. President may notify. Which basically means which of the above statements are correct? Only 2. Clear? What if we say it is not financial bill, it is finance bill? What is finance bill? Finance bill is basically a money bill. That means during budget, one is appropriation bill, one is finance bill. Finance bill talks about taxation proposals. When the Lok Sabha transmits finance bill to Rajya Sabha, it can amend or reject the bill. Then this is incorrect. Because Rajya Sabha cannot reject a finance bill. When Lok Sabha transmits money bill to Rajya Sabha, it can amend or reject the bill. It can only make recommendations. This is correct. In case of disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary in case of a finance bill. No. Which means now the answer is only 1. So if you have correctly read the question, your answer should be only 1. This is the right answer. But UPSC will say answer is B, only 2. Why? Because you have to assume that UPSC is talking about financial bill and money bill. That means it is segregating, separating the 2. It is clearly telling you that money bill and financial bill, they are separate. Similarly, when Lok Sabha transmits financial bill, it can amend or reject the bill. When Lok Sabha transmits money bill, it cannot amend or reject this bill, but it can make recommendations. In case of disagreement, there is no joint sitting for money bill, but a joint sitting becomes necessary for finance bill. That means in its answers, in its options, UPSC is clearly discriminating or separating money bill from another bill. That means it is money bill and financial bill, not money bill and finance bill. That is why B, only 2 is the right answer. What if we marked only 1? You're right, but you're wrong. That's how it is. Okay. The Supreme Court of India has held in some judgments that the reservation policies under Article 16, Clause 4 of the Constitution of India would be limited by Article 335 for the maintenance of efficiency of administration. Article 335 of the Constitution defines the term efficiency of administration. Which of the following is correct in respect of above statements? Both statement 1 and 2 are correct. Both statement 1 and 2 are correct. But second is not the correct explanation for what is statement 1. Statement 1 is correct, statement 2 is incorrect, statement 1 is incorrect, but statement 2 is correct. What is the right answer? Tell me. 30 seconds. We will discuss prelims based questions. There are a couple of questions left. Then we will take a look at the mains based questions after the break. And then we will look at the chapters of Lakshmikant. Then I will take your questions. So in any of the case, joint sitting is not necessary. No, joint sitting may be notified by the president. 46% students are right. Now suddenly there is an increase in the number of students attempting these questions. That's good. Mandal case or Indra Sani versus Union of India 1993. Supreme Court said OBC reservation is constitutional. But for that you have to meet certain constitutional requirements. Prove to us that they are socially and educationally backward. Prove that they are not adequately represented in administration. Creamy layer shall apply. Reservation cannot exceed 50% unless there are unique circumstances. And all of this is possible subject to efficiency in administration under Article 335. So statement 1 is correct. But what is this efficiency in administration is not defined in the Constitution. So statement 1 is correct, statement 2 is incorrect, C is the right answer. Consider the following statements in respect of the Constitution Day. Statement 1, the Constitution Day celebrated on 26 November every year to promote constitutional values among citizens. On 26 November 1949, the Constituent Assembly of India set up a drafting committee under the chairmanship of Dr. Ambedkar to prepare a draft Constitution of India. Which of the statement is or are correct? Easy. So what is the solution for this? Delimitation will anyhow increase the North Indian states' representation and thereby tilts the majority away from South India always. How can this issue be settled? And that's a tricky question. 72% students are right. If delimitation will be only on the basis of population, yes, the southern states will be at a disadvantage. And how can it be rectified? For that, we need a political consensus, maybe further delay delimitation and increase the number of seats by another 50 years. And let's delay this matter. Constitution Day is celebrated on 26 November every year to promote constitutional values among citizens. Correct, because that is the day when Constitution was adopted. And was it on the same day that a drafting committee was set up to draft the Constitution of India? My dear, on this day, Constitution was adopted. That means the constitution was ready. Drafting committee was set up in 1947. So this is incorrect. Statement 1 is correct, statement 2 is incorrect. Now let's look at mains based questions, but before that we will take a break. It's 7:55. We will meet at 8:10. Then we will discuss mains based questions. Then we will look at the important chapters of Lakshmika, and then whatever questions you have, you can let me know. See you on the other side of the break. Now let's look at the mains-based questions from judiciary. This question was asked in 2018. How far do you agree with the view that tribunals curtail the jurisdiction of ordinary courts? In view of the above, discuss the constitutional validity and competency of tribunals in India. How far do you agree that tribunals curtail the jurisdiction of the courts? Tribunals which were given constitutional status or which were constitutionalized by 42nd Constitutional Amendment Act under Article 323A, Parliament has the power to set up tribunals for administrative matters. Article 323B empowers Parliament as well as state legislatures to set tribunals for other matters. These tribunals have been alleged to have curtailed the jurisdiction of ordinary courts because of the following reasons. Reason number one, the verdict of the tribunals originally were meant to be challenged before the Supreme Court, bypassing the ordinary High Court. Second, curtails the jurisdiction of the ordinary courts. How? Because these judges over a period of time will be appointed to the Supreme Court. So they will lack the competency to decide the matters which are under the tribunals. For these reasons, we have witnessed the tribunals have been curtailed. We have witnessed the jurisdiction of the ordinary courts have been curtailed by the tribunals. Validity of these and competency of tribunals, whether it is L. Chandra Kumar, Roger Matthew case, Madras Bar Association, you have to cite the judgments in these cases where the courts have said that now the verdict will be challenged before the High Court and not directly with the Supreme Court. These tribunals are valid, constitutionally valid, because judicial review is also part of the basic structure. Their verdicts can be challenged before the High Court and then further before the Supreme Court. You can cite the Tribunals Reforms Act, which does not contain National Tribunals Commission, which could oversee the working of these tribunals. And competency, you can cite, barring the exception of Income Tax Appellate Tribunal, which has performed its job well because the members of the judiciary and experts put together, they decide on these taxation matters. So the competency of the tribunals, for example, National Green Tribunal, for example, the Appellate Tribunal for SEBI, they have performed their tasks well over a period of time and have disposed large number of cases involving environmental matters because of the presence of experts in these tribunals. All that is discussed, and this question was asked in 2018. Critically examine the Supreme Court judgment on National Judicial Appointments Commission Act 2014 with reference to appointment of judges of higher judiciary in India. 99th Constitutional Amendment Act was passed in 2014, creating National Judicial Appointments Commission as a constitutional body to recommend judges to the higher judiciary, Supreme Court and High Courts, to the President of India. Also recommending the transfer of judges from High Court to another High Court. This NJAC was challenged in the Supreme Court in fourth judge's case, Skara versus Union of India 2015, and Supreme Court declared NJAC to be constitutionally invalid because of violation of the basic structure. The Supreme Court, by the majority of 4:1, and when you cite these facts, it lends weight, credence to your answer. The Supreme Court, by the majority of 4:1, declared that it violates basic structure. Number one, independence of judiciary. Number two, primacy of Chief Justice of India in judicial appointments. Critically examine, which means you have to give arguments in favor of this judgment, arguments against as well, and then conclusion. NJAC does not violate independence of judiciary because of the following reasons. Constitution provided independence to the judges by ensuring that their salaries are charged on the Consolidated Fund of India, that their conduct cannot be discussed in the Parliament unless and until a judge is to be removed. They do not hold office during the pleasure of the President. They have the power to punish people for contempt. They stay in office till they attain a specific age, 65 for a Supreme Court judge, 62 for a High Court judge. But this judgment is also valid. Arguments in favor of this judgment. Point number one, independence of judges or judiciary is sacrosanct and is also part of the basic structure. The executive, as we have witnessed in 1973, 1976, bypassing senior judges, were appointing junior judges as the chief justices of the Supreme Court. Executives say in appointing the judiciary, where the executive is the biggest litigant, highest number of cases are filed by the executive, highest number of cases are filed against the executive. When state is the biggest litigant and the judges have to give orders against the executive or challenging the executive actions or challenging the legislative actions, the judges judiciary has to be independent so as to provide fair justice to the people. For this reason, the composition of NJAC was such that the recommendation given by Chief Justice and two senior judges could be vetoed by two eminent persons and the law minister, thereby violating independence of judiciary, which is part of the basic structure of the Constitution. So you have given arguments in favor, arguments against. Now the conclusion. Independence of judiciary is sacrosanct, but the Constituent Assembly gave other powers, gave other matters which provided independence to judiciary, but retained the power of appointment and removal because it acts as the vital cog in the separation of powers and checks and balances. Because of these judgments, second judges, third judges, fourth judges case, India is the only country where judges are appointed by themselves, thereby violating the checks and balances, which is an important aspect of separation of powers. NJAC should be reformed to give primacy to the recommendations of the judiciary, thereby balancing a separation of powers as well as checks and balances. So you are briefly mentioning what is NJAC and its judgment. Then you are praising the judgment, you are criticizing the judgment, and then giving a final verdict, giving a final conclusion. Your answer is done. Okay. What was held in the Kolo case? In this context, can you say judicial review is a key importance amongst the basic features of the Constitution? IR Kolo versus State of Tamil Nadu 2007, the Supreme Court declared, a constitution bench of the Supreme Court declared that all laws placed in ninth schedule after 24th April 1973, bracket Keshavananda Bharti case, all laws placed in ninth schedule after this date, judicial review applies. But even this law placed under ninth schedule can violate the Constitution but cannot violate the basic structure of the Constitution. So such laws placed in the ninth schedule can be declared unconstitutional by the judiciary if they violate basic structure of the Constitution. Right for Minerva Mills, where Supreme Court said in 1980 that judicial review is part of the basic structure, to Kyoto Holohan 1992, to IR Kolo, judicial review has emerged as one of the key component of the basic structure, along with independence of judiciary, along with theory of separation of powers, along with parliamentary democracy, along with rule of law. So what was held in the Kolo case? Number one, ninth schedule. Number two, can you say judicial review is part of the basic structure and has emerged as one of the key important component of this basic structure? Yes, because it has been reiterated multiple times. Pardoning power of the president can be challenged in the court. Imposition of president's rule, national emergency, financial emergency can be challenged in the court. The decision of the speaker vis-a-vis money bill, vis-a-vis anti-defection law can be challenged in the court. So in all these circumstances, judicial review has emerged as one of the key components of the basic structure. Answer is gone. Starting from inventing the basic structure doctrine, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy. In light of the statement, evaluate the role played by judicial activism in achieving the ideals of democracy. Give the basic definition of judicial activism, which I gave you in the lecture. In India, judicial activism implies the anxiety of the courts to pronounce upon the constitutional validity of legislative actions or executive actions when no law exists or when the existing laws are insufficient in a given situation. The judiciary has employed judicial activism in following cases: Vishaka guidelines, deepen democracy; judicial activism, where the Supreme Court is giving orders and ultimately deepens democracy in the sense criminalization of politics. That is judiciary playing the role of an activist. Judiciary telling the political parties, you mention on your website the details of all the candidates with criminal records and why did you give them tickets. It has further deepened democracy. Further deepening of democracy in ADR case, Association for Democratic Reforms, where the Supreme Court said voters have the right to know the antecedents of the candidates contesting elections. Because unless and until they know the details about the candidates, they cannot make an informed choice to decide who to vote for. Deepen democracy, nota judgment, where Supreme Court directed Election Commission provide nota, none of the above, as an option on electronic voting machine, deepening democracy in India. All these are the instances which you will have to cite in your answers. Question was asked in 2014. Will you be able to answer these questions? Yes, 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 yes. Very good. From local government, from panchayat and municipalities, what sort of questions have been asked? The reservation of seats for women in the institutions of local self-government has had a limited impact on the patriarchal character of Indian political process. 73rd and 74th Amendment implemented Article 40 of the Constitution, Directive Principles of State Policy, created local government institutions in urban areas and rural areas. Another impact of these amendments were the political empowerment of women in these local government institutions. Constitution mandates not less than one-third of the seats in local government institutions shall be reserved for women. And it has had an impact on the following areas: women participating in the developmental functions performed by the local governing institutions, women capturing political power in these local government institutions, women playing an important role in ensuring that women's issues are highlighted and decided upon by these institutions. We have seen discussions on sanitary napkins, frequent display of sanitary napkins in the Panchayati Raj institutions, where women's issues are being debated because women are now part of the Panchayati Raj institutions. But it still has had a limited impact on the patriarchal character of Indian political process because of the emergence of Sarpanchpati, where since the seat is reserved for women, it is the husband or the father of it is the husband of the woman or the father of the woman who is calling all the shots in panchayat, despite the woman being elected. That's something that you'll have to write. Would the Byju's team be kind enough to share sample answer of some questions? The weekly tests that we provide, we give you the MCQs and the descriptive questions. For all those 5 descriptive questions, we give you the model answer as well. Assess the importance of panchayat system in India as part of local government. Apart from government grants, what are the sources panchayats can look out for financing developmental projects? Tolls, taxes on property, levies. All these are the various sources from which local self-governing institutions, Panchayati Raj institutions, can generate finances, resources to fund their own developmental needs. then you'll have to also critically examine that because of three F's, functions are not properly devolved to the panchayats, finances are not devolved, and functionaries are not allocated to Panchayati Raj institutions. Then cite the report of Administrative Reforms Commission, second Administrative Reforms Commission, which had recommended more financial powers to panchayats. How the State Finance Commission is used to distribute the proceeds of taxes between the state and the local governing institutions. When you cite the committee reports, for example, the Manishankar Iyer Committee report or Second Administrative Reforms Commission report, it will lend more weight and credence to your answer. So, whenever you write an answer, first read the question and read the question carefully. Then prepare in the mind that I should mention this answer in point format because it looks better. It gives better idea to the examiner about all the points that I'm mentioning, and try and link it with current affairs and see if there are some committees which you have read whose reports you can incorporate in your answer. That will add a lot of weight to your answer. The local self-government system in India has not proved to be an effective instrument of governance. Critically examine the statement and give your views to improve the situation. Statement is local self-government system in India has not proved to be an effective instrument of governance. One, you have to say that this statement is wrong, then statement is correct, because you have to critically examine the statement. You have to give arguments in favor saying statement is correct. You have to give arguments against saying the statement is wrong, and then give your views to improve the situation. Has it proved to be an effective system of government? It has, because of the following reasons. It is an embodiment of direct democracy where people themselves decide what are the priority areas for their own areas, what are the priority sectors for their own areas. Involvement of local population to decide various developmental initiatives that need to be taken from the 11th schedule of the Constitution. It has been an effective instrument of governance because now these people also have had the opportunity to be part of making policies for their villages at the district level, and their frequent interaction with the district collector, who is the implementing authority, has led to a situation of democracy, deepening democracy at the grassroots. But it has not been effective because of the following reasons. Three F's. Funds are less, functions have not been properly devolved, functionaries are not available. Because of frequent use of central sponsored schemes, which bypass local governing institutions. And these schemes are implemented by the state government, not by the Panchayati Raj institutions, local government. MP-led scheme. All these schemes, central sponsored schemes, MP-led schemes, they are responsible for violating the rights or the duties of the local self-governing institutions and thereby giving more powers to the MLAs and MPs. How can you improve the situation? Reforms that we gave in 73rd and 74th Amendment. Direct election to the mayor, making the city police report to the mayor, more and more grants from the consolidated fund of the state, more taxation powers apart from property taxes, tolls and levies. Other taxation proposals should be given. Tax on electricity, tax on land should be given to Panchayati Raj institutions and municipalities. They should be allowed to recruit their own staff, or the law should be amended to ensure that these functionaries report to the local self-governing institutions. This will go a long way in making these local self-governing institutions effective form of government. Problem solved. In absence of well-educated and organized local level government system, panchayats and samitis have remained mainly political institutions and not effective instrument of governance. Critically discuss. If you are not educated, not enough well read, or you can't read and write, which basically means you can't make policies. Since educational qualification is not prescribed in majority of the states in India, these panchayats at the village level and panchayat samitis, they have remained only political institutions where reservation for SCs and STs, reservation for women, and direct election has led to the political empowerment of the villagers, political empowerment of people in villages and intermediate level. But it has not proved to be instrument of effective governance because of the following reasons. So basically, for all these questions, because they were asked in different years, all these questions, the source of your answer remains the same. Second Administrative Reforms Commission, 3Fs, cite the example of Manishankar Iyer Committee. All the answers here and where you have to tweak, answer remains the same. You just have to present it in a different format. Because the same set of problems that we have discussed can be used in all the answers. Local government. This is the topic from where large number of questions are asked every year. On what grounds a people's representative can be disqualified under Representation of the People Act also mention the remedies available to a person against such disqualification. What did we discuss yesterday? Section 8 clause 1, Section 8 clause 2, Section 8 clause 3. If you are convicted for these offenses, even if a fine is imposed, you are disqualified. Even if you are imprisoned, you are disqualified. And you are disqualified for 6 years after your release. Offenses under Section 8 clause 2, if punishment is given to you, imprisonment of more than 6 months, you are disqualified for your term of imprisonment, you are disqualified for 6 years after your release. If you are sentenced to 2 or more years in jail, under Section 8 clause 3 of the Representation of the People Act, you will be disqualified. What are the remedies? Initial remedy under Section 8 clause 4, where a 3-month window was provided, that remedy was taken away by Lilly Thomas versus Union of India. But what are the remedies available? You can file an election petition before the concerned High Court challenging this conviction. Further appeal lies before the Supreme Court. That is the remedy which is available to you. Problem solved. In light of the recent controversy regarding the use of EVMs, what are the challenges before the Election Commission to ensure trustworthiness of elections in India? Electronic voting machines have had an impact on the conduct of elections in India because of the speed and the scalability and anonymity that they provide. Various political parties have raised objections regarding the use of electronic voting machines, stating that these EVMs can be hacked and thereby violates the sanctity of free and fair elections. The challenges before the Election Commission of India are as follows. Number one, conveying to the electorate that EVMs are not connected to the internet because of the absence of transmitter and receiver, and as such cannot be hacked remotely. Challenges to convince to call the meeting of all the political parties, display to them that these EVMs, how they are manufactured, how they are operated, and whether they can be hacked or not, frequent testing of these EVMs in presence of various political parties. Provide the use of totalizers. But the main challenge is to convince the voter that their vote is indeed registered. For that, we have VVPAT. All these are the challenges faced by the Election Commission of India, but for that, we have the solution as well. Simultaneous elections to Lok Sabha and state assemblies will limit the amount of time and money spent in electioneering, but it will reduce the government's accountability to the public. How many amongst you watched those two videos that I gave you as an assignment? Electoral bonds and One Nation, One Election. Okay, majority have watched. Very good. And now you will be able to write an answer to this. Okay. To enhance the quality of democracy in India, the Election Commission of India has proposed electoral reforms in 2016. What are the suggested reforms and how far are they significant to make democracy successful? Reforms were suggested in 2016. Immediately next year, question was asked. 2023, there is a bill which is pending in the Rajya Sabha, which talks about how CEC and election commissioners are to be appointed. This question can be asked in your mains examination. Mains is all about current affairs. Simultaneous elections, this question was asked in 2017. Why? Because there was a debate on simultaneous elections. That was when Mr. Modi proposed simultaneous elections. Electoral reforms suggested by EC, 1 year later, this question was asked. It's about current affairs. Representation of the People Act, there were many legislators who were convicted under RPA in RPA of 1951 in 2019. This question was asked the same year. Mr. Kejriwal said, I voted for myself, but this vote went to BJP. EVMs are hacked. This was amongst the debate in 2018, saying in 2019 elections, we should not use EVMs, we should use ballot papers. That's why this question was asked. It's all about current affairs. Mains is all about current affairs. So all the polity-based topics that you see in news, that becomes important for your examination. Under what circumstances can financial emergency be proclaimed by the President of India? What consequences follow when such a declaration remains in force? What can be the answer? Let's write an answer to this question. Since you have asked a model answer for this, you should not take more than 7 minutes to write an answer. It is 8:37. Let's try and write an answer in under 7 minutes. 4 minutes or maximum 5 minutes, the question is over. Done? Check the number of words. Sir, if I'm only able to write 150 words under 250 words questions, is it okay? Answer should not be more than 250 words. If it is mentioned, answer should not be more than 150 words. You can write less than that as well. Under Article 360 of the Constitution, the President, if satisfied on the advice of the Union Cabinet that a situation has arisen where the financial stability or credit is under threat, she can proclaim financial emergency which shall remain in force unless revoked by the President. Although no such proclamation, under what circumstances can financial emergency be proclaimed by the President? And then underline the important lines. Where the financial stability or credit is under threat. So that as soon as I'm the examiner, I'm looking at this question, the question is asking, what are the circumstances? You are highlighting the circumstances. Which shall remain in force unless revoked by the President. Highlight important points. Article 360, you're mentioning article number as well. Although no such proclamation has been issued yet, following are the consequences that may follow. The salaries of government officials, including judges, may be reduced. The central government may issue directives to the states to observe canons of financial propriety. All the money bills passed by the state assemblies may be reserved for the consideration of the President. That's it. For such a question, there is no need to write a conclusion also. Conclusion is when there are different viewpoints. When you are giving argument in favor of a statement, arguments against a statement. Here, this is straightforward question. What are the circumstances under which financial emergency is imposed? What happens during financial emergency? That's it. Okay. Now let's look at M. Lakshmikant. This is the book that you have. And please remember, Lakshmikant is important only for prelims. This won't help you in your mains examination. For mains, Lakshmikant, for some facts, plus the class notes, plus newspaper. In fact, if you use Lakshmikant plus class notes plus newspaper, you are preparing both for prelims, mains, as well as the interview. When you read Lakshmikant chapter for the first time, don't mark anything. Don't highlight or underline important statements. When you're reading it the second time, underline by the pencil. When you're reading for the third time, underline by a pen. Fourth time, by the highlighter. Let's say fluorescent yellow highlighter. Fifth time, fluorescent orange highlighter or any other color. So that when you look at a particular chapter, you will realize that, okay, I have revised this chapter multiple times. If there is an orange fluorescent line, which basically means you revised it, you read it first time, then marked, underlined it with a pencil, then with pen, then with yellow fluorescent, now with orange, that means now you are reading it for the sixth time. So every chapter is to be marked like this. And what are these important chapters that you should study? Historical background, which talks about the company rule. This is something which is discussed in modern history. If you have covered in the history, there is no need to cover in Lakshmikant, but you have to cover this. Making of the constitution. But you just have to remember facts. That this committee was set up, for example, there were various committees of the Constituent Assembly. Drafting committee was headed by Dr. Ambedkar. Committee on Union Constitution was headed by Pandit Nehru. Committee on the States and Powers of the States was headed by Sardar Patel. Which were these various committees? Who was heading this committee? How many members were part of that committee? Please look at that. That should be more than enough. Salient features of the Constitution. Preamble. Then chapter 5, chapter 6, which deals with union and its territories, citizenship, fundamental rights, directive principles, fundamental duties, amendment, basic structure, till chapter 11. The entire part 1 you will have to study. Done? Then in part 2 you have the parliamentary system, federal system, center-state relations, interstate relations, emergency provisions. Part 2 complete. Then part 3 you have president, vice president, prime minister, council of ministers, cabinet committees, parliament, parliamentary committees. Part 3 you can skip. Parliamentary forum. Parliamentary group. Then part 4, governor, chief minister, council of ministers, state, high court, tribunals. You can skip subordinate courts. Part 5, complete, because it talks about Panchayati Raj and municipalities. Part 6, complete, Schedule 5, Schedule 6 and Union territories. Part 7, Election Commission of India. UPSC will be covered in governance. State Public Service Commission will be covered in governance. Finance Commission is covered in economics, but follow that. In economics also we have the GST, various constitutional bodies such as National Commission for SCs we have discussed, National Commission for STs, National Commission for backward classes. Other chapters, if in news. For example, CBI is in the news. Follow it. Enforcement Directorate is in the news. Follow it. National Investigation Agency is in the news. Follow it. Otherwise, skip. Otherwise, there are so many organizations, so many different forces. You don't have to study all of them unless or until they are in the news. Current affairs. Skip. I'm talking about, this is 6th edition of Lakshmikant. Skip chapters 66, 67, 68. Then in part 10, you have political parties, elections, role. You can skip chapter 70 as well. '74, 75, 78, 79, 80. These are the chapters that you can skip. Chapter 77 deals with the pressure groups, and these pressure groups also will be discussed in governance. So your Lakshmikant is over. Now let's take a look at some of the questions. Prasanna Vikram sir, please explain the case of Tamil Nadu recently when whether that minister is convicted or charge sheeted. What about his disqualification as a minister as well as an MP? Not an MP, MLA. You're talking about the minister who was arrested by the enforcement directorate. Then he said, I'm having a heart attack. Then he was subjected to angioplasty, but he remained a minister without portfolio. The governor had basically asked him, don't make him a minister, don't retain him as a minister. But chief minister said, this is my prerogative. Unless and until you are convicted, you will continue to remain a minister. You can continue to remain a minister. For example, Manish Sisodia or Satyendra Jain, these were the two ministers under the Delhi government. Both are under arrest. But for some time, they continued as ministers. But later on, they resigned from the ministryship. They don't have to necessarily resign. But inside the jail, how can they work? That's why someone else is appointed. Zeba Bakhtiar, what if due to president's discretion, he appoints anyone as PM who is not an MP and then nominates the same person under excellent performance in his field after the aid and advice of that PM only? Will this PM have to contest the election? No, because he's the nominated member of Rajya Sabha within 6 months or not. No. Will this PM survive for the next 5 years without belonging to any constituency? Yes, he's a nominated member. For example, Shri Uddhav Thackeray. He was not the member of Legislative Assembly. He was not even a member of the Legislative Council. But he was nominated to Legislative Council and remained the chief minister. Later on, he had to resign, but he could have continued for 5 years as well. Can a normal individual be appointed as prime minister? Normal individual means prime ministers are not abnormal. You're saying like me. Yes, I can be appointed as a prime minister. But within 6 months, I have to get myself elected to either Lok Sabha or Rajya Sabha. And also, I have to prove my majority on the floor of Lok Sabha. If I can get simple majority in Lok Sabha, I can continue. Sir, I'm student of TLP program, then where can I get class notes? Class notes does not mean the notes that I give you. Class notes means basically this annotated PPT and whatever you are writing down, running when I'm delivering a class. Those are class notes. Sir, is chapter 37 on special provision for states important? Yes, can be asked in the exam. Can election commissioner be the chief election commissioner? Yes, can be promoted as the chief election commissioner. So that the total term at the election commission does not exceed 6 years. Also, after this class is over, you will receive an email. There will also be a comment which will be displayed. That will be the feedback form. Please fill that feedback form. That will give us a sense whether you have understood these topics or not, whether you have liked these classes or not. On a scale of 1 to 5, 1 is if you are dissatisfied with the class, 5 is if you're satisfied with the class. Please share your rating. That is important for us. I told you again, previous lectures, there is some technical glitch. We are working on this. That glitch will be done away with very soon. We will restore those lectures again. You can watch them. Under Article 3, reorganization of J&K, President didn't send the bill for views of state legislature. Will this be valid or not? That depends on what the court will have to say on this matter. The judgment is reserved at any time now. we will hear the judgment given by the court. So we'll have to wait for court. How much time will it take to complete this book? Varies for individuals to individual, from individual to individual. But every day, if you can finish one chapter, fundamental rights and other chapters will take more time. But other chapters, one chapter a day, you will be able to complete it in a month. Can overseas citizen of India vote in the general elections? No, because you are not the citizen. How to remember all the cases explained by you? Revision, my dear. Gunjan, if I make notes of only this lessons, is it enough or not? But you still will have to read Lakshmikant, because there are some facts which I may not have told you. For example, there are various parliamentary committees which we have not discussed, because I told you these are factual things. You have to go through them. So please read Lakshmikant as well, point by point, and then underline important areas. Sir, they are not even giving class PPTs to TLP student. My dear, for example, you have bought an iPhone 15. Will you get the features of 15 Pro as well, 15 Pro Max as well? No. That's why there are three different programs that we have: an offline classroom, a tablet learning program, online classroom program. So if you have enrolled for tablet learning program, obviously you will not get all the features of the online classroom program. That's the difference. Graft case means corruption case, where you have taken bribe. President dissolves legislative assembly, where? What is the basic difference between motion and resolution? All resolutions are voted upon, all motions are not voted upon. Does Lakshmikant help in mains questions? Not much. Will Byju's provide free sessions for other subjects also? No. Sir, can you explain the concept of privy purse? This was the promise given to former rulers of the princely states, that you give up your sovereignty, merge your princely states with the Union of India. For that, we will give you some money every year. This money is known as privy purse. This money depends upon the revenue of that princely state. That means no questions asked. This is the purse. This is the money that you can spend. Privy purse. Sir, what is doctrine of colorable legislation? What you cannot do directly, if you do it indirectly, that is what we call colorable legislation. Yes, I will miss you too. Tomorrow morning, tomorrow onwards, I don't have to come to the office before 6 o'clock in the morning. Can a government employee file a petition in High Court if she is not getting salary? Yes, she can. What is doctrine of proportionality? For example, there is a mosquito in this room. Clear? And I have to kill that mosquito. What are the options available with me? Can I use that hit bat? that electric bat to swat at the fly and the fly is dead, right? Or I can use Mortine, All Out, whatever options are available. Or I can use those agarbattis, those rounds, what are they called? That's also an option. I can also use an AK-47 rifle to kill this mosquito. Or I can use a bomb, destroy this whole building, but this mosquito will also die. Or use a missile, or use an atomic bomb. The purpose is to kill this mosquito, and there are various options. We have to find the best possible option, proportional response to this. That is called doctrine of proportionality, which primarily means if the state, if the government has one objective in mind, take the route which does not violate fundamental rights. For example, I have to provide, this is the doctrine which was propounded by the Supreme Court in various cases. It was used in the Aadhaar case as well. Aadhaar case in the sense, what is the objective of the government? To provide benefits, scholarships, pensions, subsidies to the people. For that, what are the various options? If there is an option to have Aadhaar linked with your bank account, linked with your mobile, that is one option. Or the other option can be, we will give you money, but we will ensure that you have to come to us. You have to give all your details one by one. Then we will process your claims. And at the end, we will give you the money. What is the easiest, most proportional way to grant you subsidies? That is through Aadhaar. It's a proportional response. For example, today there are talks about Hamas and Israel. What Hamas did on 7th of October was wrong, bad, horrible, killing children, women, taking them hostage, and those are common citizens. It's not a done deal. But what will be the proportional response of Israel? Does that mean in response to what Hamas did, Israel will bomb the entire city, entire area, will also bomb hospitals or uh, camps, relief camps? That will not be proportional response. Doctrine of proportionality. Uni, what's your question? Can we see these classes later? Yes. Is sedition same as defamation? No, you can defame an individual. Sedition is if you are using violence to overthrow the government. That is sedition. Will there be any impact on private jobs in case of financial emergency? No. Very important question. What is constitutional morality? Court has to look at a particular case. The Supreme Court has to decide a particular case. Will the court look at this particular issue from the morality of the people? What do people think about this issue? And then we will decide. For example, Section 377. Whoever voluntarily engages in carnal intercourse which is against the order of nature. It is a crime. It is homosexuality. Is Section 377 constitutional or not? When the court has to look into this matter, the court will not look into whether society accepts this or not. What is the morality of the society? Is society ready to accept LGBTQ community? No. The court will not look into the morality, the contemporary morality of the people. The court will look into the morality of the constitution. And where is this morality found? Preamble. Fundamental rights. Preamble talks about justice, equality, liberty, fraternity. This is constitutional morality. So if today's society believes in, let's say, monogamy, today's society believes in that there has to be marriage between the opposite sexes only. Today's morality, the society believes that bribe is not allowed, bribe is something which you should abhor. But forget about this morality of the society. When the courts have to take up any matter, it will look at the constitutional morality. Even if people are against LGBTQ relationship, we still have to agree to that. Why? Because Constitution believes in justice. Constitution believes in equality. Constitution believes in privacy. Constitution believes in liberty. Every decision of the court will have to keep these things in mind. Constitutional morality. Saima, what's your question? Sir, I am enrolled student of Byju's in recorded class, but I think live lectures are better than recorded lectures. What is your take on this? I agree with you, because live lectures are not better or worse. Lectures are same, but it's just the way you are presenting it in the form of live interaction that is always better. You get up early in the morning at 6 o'clock. Unless and until I revise yesterday's class, I won't be able to understand today's class. So you will have a disciplined preparation approach because of the live classes, and that is why live classes I would also prefer if I was at your place. How should we do PYQs for mains? Do you think we should do it together or separately? Together, no. When you discuss judiciary, when you complete judiciary chapter, look at all the PYQs for prelims as well as mains from judiciary, and then write answers. Today is the last class, yes. Sir, you skip SPC, SPSC, and UPSC chapter. That's why, my dear, I told you we will discuss that in governance, role of civil services in democracy. CAG also comes under accountability. CAG, Right to Information Act, the Central Information Commission, Lokpal, Lokayukta, we will discuss in governance, in transparency, accountability. And whenever you're mentioning, please answer my doubt, please also mention what is that doubt. Because there are lots of students, I cannot go back and start searching your name and your question. So whenever, either copy your question again, post it again, I'll try and answer. Sir, I will give exam in 2026. Should I buy Lakshmikant now itself? Yes. Sir, you always skip my question. Poonam, I'm sorry, but please tell me what's your question. Since last Friday, you aren't answering my question. Sorry, but what's that question? Tell me. Do we need to read social justice book that Byju's has sent? Uh, that you'll have to check with the teacher who will teach social justice. I have not received my books yet. Okay, I can see there are few questions on the books. Uh, I will get back to you today about the books. There was an issue with the books in the sense that the vendor who sent these books, we have a warehouse in Delhi where all these books are stored. And then, unfortunately, a few months ago, there were floods in Delhi, and all those books they got destroyed. Now we have placed another order, but now that order is taking a lot of time. But hopefully, today we have a meeting on that. How do we resolve this? And hopefully, in 15 days, we will be able to start dispatching those books. Will I be able to complete syllabus within 6 months? Yes, you can. Sir, why are SME saying that if you buy optional classes, then I will dispatch it earlier? No, that is wrong. So it basically means that person is trying to force you to buy the course. Don't do that. Even if you don't buy the optional program, you will still get your books. That's wrong. Shabir, what's your question? Kindly open first slide of Lakshmikant chapters. This one? Your handwriting, even if it's not good, but it should be legible. The examiner should know, read what you have written. Santhanam committee was set up on corruption. What is Tripura land? That is the demand by some sections of Tripura to have a separate state for the tribals. This is led by Devajot Burma. He demanded a Tripura land. If you want to enroll in online program, you need to take tablet learning program with it. Is it mandatory? Well, that is optional. Optional in the sense, even if you take live classes, you will still get the recorded versions, recorded lectures as well. So even if you don't take it, you will still get that. For that, there is no additional charge. Can you tell me preparation strategy along with graduation? What graduation? BA, BSc, BTech, MBBS? What sort of graduation? BCom? I'm studying for the last 3 years but not qualifying prelims. Can you please guide me? How can you contact you? Please drop me a mail. I may be late in replying, but I will reply for sure. Does state election commission exist in original constitution? No, it was given a constitutional status by 73rd and 74th amendment. Will Maratha get reservation? That's for the government to decide of Maharashtra. And then later Supreme Court, because previously Maratha reservation was struck down by the Supreme Court. And we have discussed that in Article 16. When can I expect your last recording is in working? All these classes, the recordings of these classes, you will be able to watch. I understand there is a technical glitch right now, which will be resolved by today so that you can again access those classes. Please do not worry. Are you going to start a new polity batch? We have to launch a new course for 2025 exam. For 2024, this is the last class. This is the last batch. Is it enough to read Baiju's current affairs or need to read newspaper? I would recommend, always recommend you make your own newspaper notes, you read your own newspaper. But if it is not possible under any circumstance, then the only option which is left is following our current affairs. Will you teach polity optional? My dear, there is no such optional as polity. Political science and IR, but I don't teach, I teach only GS. No money can be withdrawn from Consolidated Fund of India without the approval of the CAG. No, CAG's permission is not required. Parliamentary permission is required. Then whatever money, how many articles came into force on 26 November 1949? The provisional government, the laws related to citizenship, they came in force on 26 November 1949. Sir, after listening to your classes, I got interest to do the law. What do I say? All articles need to be remembered? No, only the important ones which are in the news. Do we have to make notes of Lakshmikant? No, don't make notes of Lakshmikant, because if you make notes of Lakshmikant, you're writing another Lakshmikant. That's why I told you underline the important points. That's it. Do nominated members of Rajya Sabha have equal power with respect to elected members? We can't say power, because we can say role. Do they have the same role as that of elected members? Yes, they can also become ministers. They can also become part of the committees. They also have the right to vote. So they have an equal role vis-a-vis elected members. The only thing is that they do not participate in the election of the President of India. Okay, so Siddhanta, sir, you mentioned some points of Lakshmikant are not correct. How do you know? How do we know which one is wrong? And I have marked them in a sense when I told you about vice president's removal. Lakshmikant says absolute majority, but I told you that is wrong. It is effective majority. So all those mistakes we have communicated one by one. Please tell a better way. Sir, you are not answering my question. This is discrimination with me. If done deliberately, it is discrimination. But for that, I have to see your question. Seema, where is your question? Are nominated members of the parliament private members? Anybody who is not a minister is a private member. Whether you are nominated or elected doesn't matter. You are not a minister, you are a private member. Can average student clear this exam? Most of the students who clear this exam are average students. How much time to be given to current affairs per day? 1 to 1.5 hours. Sir, is this session enough for UPSC exam? Hopefully, yes. For polity current affairs, can I follow Baiju's monthly topics? Yes. Tejas Hegde had sent a mail yesterday. During President's rule, it is said that maximum period of rule is 3 years. In first instance, does the first 6 months of the President rule include 60-day period? Once approved by the both houses of the Parliament, it continues for 6 months. Byju's has any offline classes? Yes, we have offline classes in Delhi, Bangalore, Chennai, Hyderabad, Kolkata, Lucknow, Jaipur. Can a nominated CM from Legislative Council introduce a bill? Yes. Which constituency does nominated members Lok Sabha represent before 2020? Before 2020 or after 2020? There has been no change. The only change is that there are no Anglo Indians who are to be nominated. Nominated members, they don't have a constituency. So they're not nominated from a constituency. They're nominated from entire country, from the fields of art, literature, science, social service. Ritika, what's your question? Love jihad. Love jihad is a term which is used where it is alleged that Muslims, they deliberately trap non-Muslim women into love and then marry them with the sole purpose of converting them to Islam. That is what is known as the love jihad. Can I take offline class? Your call, my dear. How to analyze current affairs and able to connect with questions. For that, follow the daily newspaper analysis that we do on YouTube and watch our weekly webinars. The weekly current affairs webinars that we do on Tuesdays and Thursdays, please attend them. More than enough for your current affairs preparation. Will women's reservation bill apply before 2024 election? No. It will apply only once the census is over, then delimitation is over, then it will apply. Do you take offline classes in Bangalore? I will be from the next year, from January. In Delhi also. Where can we find weekly webinars of Byju's? That is available only for the paid students, the enrolled students, uh, Tuesdays and Thursdays. Can I take morning and evening batch simultaneously? Yes. Sir, how do I evaluate my answers of mains and find my weak points? That is why write your answers, share it with us. We will evaluate, give you feedback, and tell you these are your weak areas, improve upon them. Because on your own, you cannot decide what are your weak areas. Because it would be violation of principles of natural justice. Nobody can be the judge in his own case. You're writing your answer, you're checking your own answer, and then deciding whether your answer is good or bad. If finance minister is from Rajya Sabha, introduces a budget, where does it present? Presents in the Lok Sabha. That is why even ministers from Rajya Sabha, they come in Lok Sabha, speak in Lok Sabha. Basically, this budget is not introduced by the finance minister. This budget is an annual financial statement to be introduced by the president, to be tabled by the president. And on behalf of the president, it is done by the finance minister. I'll miss you too as well. That is it for today. And if you have enjoyed these classes over the past 27 days, 27 classes to be precise, in more than 95 hours, we've been able to complete Indian polity for prelims and mains examination. There are some topics which we have not touched, but we will touch these topics, discuss them in governance, in social justice, in other areas. If you have enjoyed these classes, you will get a feedback form that will be presented to you via mail. That will also be part of the comment section. Please fill that form and let us know whether you have enjoyed these sessions or not. See you next time when I see you. Till then, all the best. Hope all of you would clear this exam. Be confident that this is something that you can do, and there is no power on earth that can stop you from realizing your dream. The moment you're fully confident, whatever be the circumstances, you will be able to clear the exam. But there is a thin line between confidence and overconfidence. Don't be overconfident, but don't be underconfident as well. Confident about your approach. The only thing that you have to do is complete syllabus and link your syllabus with the current affairs. That's the only thing that you have to do. And once the syllabus is over and side by side you're practicing your answers as well, what is the need to worry? Why should you be worried? Bye bye. Take care. All the best. Take care.